Alrighty, we are now live. Good morning or good afternoon, depending on where you are joining us from, and welcome to our LinkedIn Live today, hosted by Envoy Global. My name is Eric, and I'm excited to welcome today's guests, Antonio Lamb and Alistair Mason, and we're here to talk about the UK's new immigration measures. A lot of big news coming out of the UK in recent weeks, and Alistair and Antonio are here to kind of break down the news, offer their insights and analysis, and address any audience questions that you might have. If you are listening and you do have a question, please go ahead and type it into the event comments feature that you should be seeing on your screen, and we'll do our best to address it. And with that, Antonio and Alistair, thank you so much for joining us. Antonio, you are the the Director of UK Immigration here at Envoy Global, and Alistair is a senior associate at Smithstone Walters, an Envoy Global company. So, Antonio and Alistair, thank you so much for joining us today.
Oh, thank you for having us.
Sorry.
So, Antonio and Alistair, I just want to quickly turn over the mic to you, to both of you, to quickly, discuss your background and just how you got started in UK immigration, and just kind of provide some few fun details, if you will.
Fun details, eh? I'm not sure there's much in that. Well, it is very fun, UK immigration. My life generally not as fun. But to be honest, I fell into immigration about 20 years ago and haven't looked back since. So I've been an immigration lawyer, advisor at various different firms. Always been in UK immigration and trying to get our clients the right stuff. In terms of people, in terms of compliance, in terms of policies, making sure that everything's shipshape. So we have the headache, effectively. That's the idea of it. And I'm sure most of my colleagues would say exactly the same.
Nice. And Alistair?
Sure. I've been at SSW, part of Envoy now, for the past 12 or so years. And I've seen, like Antonio, I've seen the immigration system in the UK move from those 120-page paper forms that we used to fill out for European citizens pre-Brexit through to a mobile phone app that you can now enroll your biometrics using, and everything in between. And today my world straddles UK, small clients, large clients, technology, and a lot of Europe as well. So I sit between all worlds in the immigration industry, really.
Nice. Awesome. Well, thank you both for sharing some of your backgrounds. And I think with that, let's hop into our main discussion for today. We have a lot to cover, a lot of analysis to share. Real quickly, though, I know I am the host, but I am dealing with I'm still trying to get over a cough. So apologies if I kind of my voice goes in and out, or if I have to mute myself unexpectedly. I don't want everyone to hear my cough, so just letting you know. All right, so kind of let's, Antonio and Alistair, just want to set the scene. Obviously, a new UK government led by the Labour Party was recently elected. And a few weeks ago, they released a big white paper called Restoring Control Over the Immigration System. So I think to start, can both of you just kind of set the scene in terms of where does UK immigration stand as we're talking in May of 2025? And why did the white paper come out now? And so, Antonio, maybe we'll start with you.
I think there was sort of a heightened peak in terms of numbers that kept being reported, in terms of entry to the UK. And it's not just simply the news that we see in terms of illegal migrants coming to the UK, but also legal migrants, and obviously statistics that have come out, showing over 900,000 people coming in, net migration, that type of stuff. That really sort of pushes the sort of boundaries to the sort of the new government or the current government saying, well, something sort of needs to be done, or at least they think something needs to be done. Hence, they wanted, I guess, or still want to sort of create a system where they feel could be controlled. At least that's the aim. And hence, I guess, the white paper, hopefully, to address, well, what they see potentially as a problem. Debatable, of course, but nonetheless, I think that's the aim of it.
I agree, Antonio. I think, and within that 900 number that you mentioned, it's the breakdown of it that they're trying to tackle. So low skill versus high skill. And again, there's a debate around that. What is low skill and what is high skill? But the white paper is clearly out there to reduced the 900 and also changed the breakdown of who the 900 are towards that highly skilled group.
That makes sense, definitely. So the white paper itself, so it was recently released. It's fairly lengthy. I think it's something like 80 something pages of sorts. We're going to hop into a few important parts to it, but I guess, Alistair, can you provide a synopsis of what it proposes?
So I'm going to focus, I think, by and large, we'll focus on work routes. We're going to touch briefly on family, but we're going to focus on work routes, routes that would impact the corporate clients that we work with, the organizations. And I mean, at a very high level, the white paper is looking to change the skill level that must be adhered to when you're applying for particular work visas in the UK. It's looking to amend the salary levels that go alongside it. It's not only impacting sponsors with their hiring ability because of salary and skill level, but it's impacting individuals as well. The biggest change being the 5 to 10 year eligibility for settlement or indefinitely to remain permanent residence, as it's often known in the UK. So there's a mixture of things that are being implemented, whether it's skill level, English language requirements, salary levels, a view to remove the immigration salary list, temporary shortage introduction, etc., which all impact sponsors, right through to some changes surrounding dependents eligibility for visas, and this idea of earned settlement, possibly over a 10-year period, that undoubtedly have an impact on sponsors, but are also aimed at the individuals. So I think the white paper it's far-reaching insofar as it's not just organisations and sponsorship, but it's also the people that work for those organisations that could be impacted as well.
And Antonio, it's important to note that this white paper is not set in stone yet. Is that correct?
No, it's not at all. It's literally the first. Well, I say literally the first phase. Although I'm sure ministers would have already have an idea, or at least a framework in whether drafted somewhere in the dark room of how this should work, and hence this is the sort of white paper. The white paper effectively is the proposal that it's going to make, and hence there are some details even before the white paper that has been sort of surrounding or floating around in the media, but not least already in these sort of 86 odd pages of proposals effectively, but it has to go through a certain process anyway, right? So this is really the publication stage, I will probably call it, and so everybody sort of read and comment and obviously discuss potential impact. There will be a lot, by and large there will be quite a few sort of consultations, mainly of course the settlement one has already been talked about, as Alistair said, the 5 to 10 year, there will be a consultation that's going to be introduced later on this year, as already dictated within the white paper, but also I think the Home Secretary has already said that within Parliament anyway as well, as part of her question. And then it goes into the sort of legislation drafting or presentation. For most parts anyway, will be presentation of the draft rules, let's just say. There probably won't be a lot of parliamentary debate, I wouldn't think, because it's immigration law, so they can change it. And what we will see would likely to be a statement of immigration changes, which will sit there for 21 days, effectively, unless there's any sort of major issues with that. And then it will become law. But, there will be a process that needs to go through. But I think the longest process that we'll probably be looking at will be the consultation part of it, and rightly so as well, because it does affect a lot of people's lives in that sense, and some may need to be debated actually, talking about that, because some might touch upon primary legislation such as the citizenship part or the levy for students in terms of the levy on effectively a taxation for income on higher education providers as well. So those might need to be debated in itself, but yeah, we're in the first phase.
Antonio, do you think there's a chance that they might break out elements of it and introduce it with, as we've seen like recently with some changes, and not so recently with others, break it out without that 21-day notice period that we like that I've become so used to, where you get the immigration rules set out, and then you've got 21 days, you can warn your clients, you can ease them into it. But some of the bigger changes, like the 5 to 10 year or dependent impact, or even the move from level 3 to 6. I wonder if they would try and get them out, announce them at lunchtime, and they're required by midnight.
Yeah, I mean, we all remember those, right? I mean, the famous one, I guess, was me working during pandemic, and it was the investor one. Right?
Investor, yeah.
I remember the previous government, Home Secretary literally announced within an hour or a couple of hours or whatever may be the case, it was just literally gone. That's it, because of the rush or the fear of the rush. And then I think there was a student dependent or something along those lines that's just sort of introduced. I think some elements will, definitely. I don't think all of it can. I think the 5 to 10 year one, I think will be really hard push for you to do something like that, right? Because there's such I mean, one, she has the Home Secretary has already promised in the consultation, so I doubt she would do that. But two, also, it does have that sort of great impact on it. Not least, I'm sure every immigration lawyer sitting around talking about this would be thinking, well, hang on there, does it impact people who already have a visa, whatever it is? How would the law be? All of that type of stuff. So you're almost inviting litigation, or at least judicial review in some way, and I don't think that would be the intention. I think it's probably an orderly thing. I think for this particular one, but certain things, I think they will want to push it very quickly, whether or not they will go through the formal route or the not so formal route, in that sense of whether or not there's a heightened risk of piling on effectively application, like fees, for example, all of that. They probably just slip it into the standard statement of changes. But certain things, they may, But I think those would be low impact, but it will always be high impact, but basically so that the government doesn't have to deal with 100,000 applications in one night, basically. I think that's probably the expectation, right?
Yeah, I think so too. I think there's the question that I would have for them is, if we had that choice, is what will be retroactive? What will impact people already in the system, if anything, because it isn't categorically stated that it will. And then if you are making changes, how much notice will people have? Will it be the standard 21 days, or will you introduce some of those sort of announced at midday applicable and midnight rules? But I think that's some of the questions to be asked, but I think there are things that people can do to prepare for that. So remains to be seen.
So look, diving into the white paper, Antonio and Alistair, before, during our prep for the session, we identified, what we are calling like the 5 most important things, and the 5 things that we wanted to kind of dive further into during the course of this LinkedIn Live. So Antonio, let's start with the skilled worker visas. As you were reviewing this white paper, what stood out to you with what the government is proposing when it comes to skilled worker visas?
I think for work visas generally, really, but for skilled work in particular, it's obviously what Alistair has sort of summarized earlier on, which is the skill level. Of course, the so-called RQF level 3 to level 6, so what they sort of call mid-level or not so highly skilled job to skilled jobs, effectively. That's been... It's striking, but not striking, so to speak, because the so-called RQR level 3 and RQR level 6 have been sort of bouncing around for the last few years anyway. So it's something that we've seen taken away, reintroduced, obviously by previous government again, and then going to be reintroduced again. So that's striking in that sense. Of course, the other thing, of course, is the shortish occupation list, or what we used to call shortish occupation list, which then sort of turned into immigration salary list, and now it's going to be a temporary shortish list. So again, that's always going to be tinkered with. So again, not so surprising, because those are almost the easy wins, I would probably say, but certainly something that is quite eye-popping, because people keep seeing the chop and change, and I think even for an immigration advisor, it gets a bit annoying rather than confusing. But that's certainly, I think, one of those. The other thing I probably think it could have a great impact, but also a bit too soon, again, would be probably the salary threshold. Again, that's going to be looked at, of course. So we've just had a change recently, obviously, and stock code changes as well from 2010 to 2020. And then with that, we went from 25 percentile to median effectively. And now I wonder what we're going to see. So those are some of those things immediately that I can see. But of course, it links into not just the workers themselves, but also the dependents as well. Of course, there's the introduction of English language, of course, and also they might need to pay more to have the pleasure of bringing their family members in. So those are the key sort of stuff, aside from obviously cutting a whole route out of the picture as well. So out of social care, absolutely taking out the route by 2028. So those are, I guess, those are the striking ones.
Mm-hmm, mm-hmm.
It varies as well from industry to industry, and I think like that's, as you said, Antonio, that level 6 has always been lurking. So level 3 being A level or high school roles,
Yeah.
level which we got used to in the last few years. But actually, a lot of businesses in the legal, finance, IT sectors, they don't rely on those level 3 roles. They're always level 6. So it's kind of business as usual for them, really, these changes. I think the changes are hugely significant for those organizations that rely heavily on those lower skill roles. I call it lower skills, lower skills in the eyes of this white paper roles. And some of those would be like, well, obviously, adult social care is its own consideration, but hospitality, and even some departments within some of those industries I mentioned, like some finance roles, supporting arms of businesses, they won't be eligible for visas in the future. So for me, it's like actually the impact of raising it to level 6 across most clients that we work with will not be huge, but in certain industries it will be, that decimates the ability to sponsor unless they make some allowances, which they've alluded to for particular industries or roles.
Can you expand on that last point you just made?
So this is the sort of fresh lick of paint on the immigration salary list, shortage of occupation list, and the latest name is the temporary shortage list, and how it could be used for short-term or long-term, with MAC input, ability for industries as a whole, or certain roles to still be eligible for sponsorship, even though they wouldn't necessarily meet that degree level qualification. And so I hasten to add, it's not. Well, I expect it to be like before, where you don't have to have a degree, you just have to be in a role that would be equivalent to a degree level role, which that often gets confused. You could have 10 years, 15 years of experience, you'd still qualify, even though you don't have a degree. So yeah, but that's one of the many unknowns, I think, at the moment. We don't know what that list will look like. But yeah, I do wonder if it's same thing, different name maybe, but we'll see.
Anthony,
Yeah, I mean,
were you going to say something?
yeah, I was just thinking sort of ahead is what they really want to do, right? I mean, I guess the sort of ultimate goal to change, do all this chop and change is, I'm hoping anyway, is that, you know, as the white paper would probably suggest, is they effectively want to sort of stop reliance on even legal migration, right? Forget about, you know, whether or not this is a correct thing or not correct thing, whatever may be the case. I guess the goal is to do that, right? And I hope this chop and change at the very least from, you know, 3 to 6 is not going to be the forever moving goalpost, so to speak, because I think it's a bit nonsensical, personally. I think it doesn't really do anything. I mean, the Mac can probably tell a bit better than that, but I think it's not very helpful. It certainly limits a lot of numbers, certainly, but I don't think that in itself would limit numbers. I mean, we've certainly see already on the ONS, the latest ONS, so the Office of National Statistics, for net migration in 2024 is halved from 2023, just simply taking a route out, for example, right? So the family members of, you know, a lot of that was because of that, and of course the combination of things like, you know, increasing salary threshold and all of that. So it's going, if we just purely looking at numbers, then yeah, I guess it's going in the right direction. But I guess the route is not just skill level or salary threshold, is actually, does the industry or do industries require this, right? And I think that's what Mac really needs to sort of look at, and just tinkering with the level 6. I think it's probably a band-aid, I would probably say, to a very gaping wound.
I think I really hope that temporary shortage list takes into account the fact that skill level is not synonymous for need. like they don't go hand in hand. Like industries
Yeah.
need people with different skills, and that's what I really hope comes out of the white paper is that's considered in that list. The other thing that it reminds me of is back in level 6 days, where you would have an organization that really wants to sponsor somebody, but it wasn't really a level 6 role. And you had to align it to a SOC code, and maybe a few codes could apply, and they'd look at a code that's level 6, but there were other codes that were level 3. And I think that's something that that sponsors need to be really heightened of now, because if you've got these people that you're sponsoring in level 3 roles, hypothetically, they may be able to continue on their journey through the immigration system. But if you bring someone in and they don't qualify because they're new into the system, it's after the rules have changed, and you say, well, actually, they're going to be on a level 6 code, but you've got these people doing the exact same job on a level 3 code from before, that's going to raise questions. And we've seen that over the years. Basically, roles should have the same code throughout your organization.
Absolutely.
If there's variations in seniority, fair enough. But and I think that's something that clients or sponsors could do now, is do a bit of an audit, know exactly who's on which code, and in the future, these codes won't be permissible for sponsorship. And if you do sponsor somebody on a different code, it might jeopardize your current workforce. I think that's something that 2018, 2019, that was something we'd have frequent conversations about, and I think it's possibly coming back to the fore.
Alistair, how would you what would be the best recommendation for companies to do that type of audit?
So I saw a client yesterday, and we were looking at knowing who their sponsored workforce is in detail. They'll know the names, they'll know the expiry dates and nationalities, but what code are they on? Could you sponsor that role in the future? If this is another topic, but if it goes from 5 years to 10 years sponsorship, what would be your outlay to sponsor that person for that long? All of these things, you can't deal with the unknown of whether this will be applied retroactively, when it will come into force, exactly what the temporary shortage list will be. But what is under your control is, well, how many people do I have? When do their visas actually expire? Can I extend them early if I need to? What would be the cost if I had to sponsor them? All these things are under your control, and it's really just, I think, my advice is build up this picture of data, so you know your next steps when they arrive, I think.
That's great. Antonio, for companies who maybe aren't as familiar with the UK system, what would your, just general suggestions being about how they're viewing their talent strategies within the country, in light of this white paper, and they're maybe planning for the next, 2 to 5 to 10 years?
I think there's a lot to consider. I think what Alistair said is certainly something that we have already started to implement for our clients, for example, in terms of really looking at standardizing those job coding to see what's your need in terms of volume, and also what type of jobs that you need, and working really with talent as well, talent acquisition as well, to see where you're getting these people individually, right? There's a term that keeps saying self-sponsor. I really hate that term, by the way, but and it's not such a thing. There's even without this white paper, there's something called genuine vacancy, right? And so self-sponsorship doesn't, there are criteria that need to be met, so to speak, right? So I think that's one of the things that certainly we work with our clients to make sure, hey, look, let's look at your data and really form that sort of what Alistair said, from that sort of data dashboard, and say, this is what your population looks like. This is what you're going to look at in the future. I think that's one of the strategies. The other strategy is we have to look at some of the positives also from the white paper, not just the bad stuff, so to speak, right? I mean, yes, we might have all of these changes in play, but those who are already on the visa, effectively sponsored visa, RQF level 3 or 6 will not affect them. We know that throughout the so-called migration journey. Obviously, other things will be affected, but at least that particular part, it won't. We do need to standardize it. So it's not an immediate, cutthroat, that's it, done, you're gone. So that's a positive. The second positive, I guess, we can see is also look further afield, right? I mean, you can still sponsor people on graduate. Again, we're not talking about every single sector here, but a lot of sectors are not reliant purely on the RQF level 3 sort of jobs, right? A lot of our plans, for example, and certainly from various organizations that I've worked in as well, is they rely heavily on graduates, for example. Right, we're going to talk a bit about graduates later and how they're going to shorten the visas, but certainly graduates are still sort of available where you don't need to have that sort of sponsorship to begin with. Let's just say they are opening up more, for example, as a positive, again, on the HPI, so high potential individuals. So again, overseas graduates from prestigious universities, for example. They're also bringing in, other measures, trying to sort of innovate that, trying to get things moving. We're already talking to clients, some of our clients, to look at more interns, for example, local interns. That's one of the ways to sort of, again, we're not talking purely just immigration. It's about actually diversifying your workforce now and say, can this role actually be moved into something else? Again, a lot of roles can't, the senior ones, and we know there are shortages, but certainly part of those we certainly talking about, do you have an intern program that helps? Those are the type of things that at the very basic we are looking at. But also the most part of the consideration, I guess, the business needs to start looking at is finances as well. Employing an individual is not just about how complex it is, but also about the cost. So instead of now looking at, your 5 years and the person could potentially be, we might be looking at 10 years and the person could potentially be, plus an increase of immigration skills charge. So financial planning is also very important. That's something that we're working and basically say, what's the sort of threshold that we are looking at to plan your sort of workforce or your recruitment efforts effectively.
I like that, the idea that HPI, like, you should diversify. You have a diverse workforce, and you should have a diverse reliance on the immigration system. Like, don't use the HPI, use the graduate route. It's a great stepping stone, I think, to long-term sponsorship if you need it. But be aware of, like, when you're hiring somebody, if you're in talent acquisition, when you're hiring somebody, be aware of what the current visa is, but be aware of what's next in the chain. Like, if you're hiring someone, and I had another client I had a really good talk with last week, talked about how they hire people on roles that wouldn't qualify currently for skilled worker based on the salary. They hire them on a graduate visa, but they're very transparent, and they say, look, we're going to hire you on this visa. You'll get some experience. We'll get a fantastic person to work for us, but it will not be a long-term option because we cannot sponsor you legally. So I think it's that long, like, always thinking ahead and knowing that, these can be great stepping stones, but for some groups they will lead onto sponsorship, but for others you need to be aware that it's not the end result.
Well, speaking of graduate visas, Alistair, that brings us to the second thing we wanted to discuss today from the white paper. And this white paper does propose some changes to the graduate visa. Is that correct?
Yeah. So the white paper giveth with one hand outside of the UK. It's expanding the HPI routes into the UK, but it taketh for the other hand, and it's removing the duration, or it's not removing, sorry, curtailing the duration for which graduate visas are given. So graduate visas, again, like, we go through these new and innovative categories in the UK, but it's really just a rebrand of something from before. There's lots of that in this white paper. So graduate visa, PSW, post-study work from years ago, valid for a maximum 3 years if you have PhD, 2 years otherwise. And they're looking, I think it's 18 months, isn't it, right, Antonio? They're looking to shorten it to the validity period. And I've had some feedback from individuals saying, that's not great. It doesn't give us flexibility. But my experience has been that from an individual perspective, this time is lost time. It doesn't count towards your 5 years you need for residency. So once people are on this visa, actually, they want to get on it, find the sponsor, and get off it as quickly as possible. Most people, I think, would be quite keen to do that within 18 months, certainly. So I think from an individual perspective, is it great? No. Like, it's nice to have that time to find your sponsor. But is it the end of the world? I don't think so. And for sponsors, it is also a stopgap option. It's not a long-term solution to a member of staff in the UK, whether it's 18 months, 2 years, or 3 years. If you want them beyond that, you have to find a solution for that, whether it's something they can sponsor themselves, like a relationship-based, ancestry-based, etc., or your sponsorship license. But yeah, I don't know, Antonio. I think you mentioned about the HPI and how the expansion of it was great, but it seemed strange that it was going in the opposite direction
Yeah,
within
they
the UK.
almost. Yeah, I wonder whether they're going to keep the 2 years. To be very frank with you, for the HPI and the or in this sense, with PhD, I guess they probably would keep the same thing. But yeah, they're going to expand the list of universities, right? And
Yeah.
I wonder whether or not they're going to expand more. The idea, I guess, is to sort of say messages. They want to attract the best and the brightest, so to speak, right? It's this sort of similar vein. And I guess, again, back to sort of your question earlier, Eric, as well, is, the global talent stuff, right? I mean, they're going to also expand that, make it easier for individuals to do that. Innovative founders, that those type of things. Those are things obviously to look at, but also, yeah, it's almost almost creating a two-tier in that sense, graduates, so to speak, right? But I guess in the white paper, I guess sort of the difference is the government sort of almost say, well, you don't need the graduate route. You can go into other things like the innovative founder route. So yeah, we're taking 6 months away from you, but we'll hopefully make it easier for you to get on the innovative founder. So if you want to set up your business, and you have a really truly good innovative idea, that type of stuff. So I guess you take away something and you give something, right? I want to see what the rules look like, but certainly
Yeah.
it doesn't look all doom and gloom in that part.
I think I'm really interested to see what they do with Innovator Founder, because I don't think we've had a good route
No.
for that for years, and I think that it's not been well thought out, but it's also incredibly difficult to have a route that really relies on creativity and entrepreneurialism, which is in complete contrast to what the immigration rules are, which are about control and direction and focus. And it seems like I can't see how they can gel the two together. And if they can, then well done. I'd like to see it. There's a small change on the expansion worker as well, doubling the number of people that can come. But we've had not great experiences with the expansion worker. Again, it seems to be like disconnect between rules and reality, and ownership structures, and a desire for a route to settlement from day one, etc. I don't think it's been a huge success, if I give my opinion on it. And I think really actually doubling the number of employees that can come to the UK is just it's a nod, but it's nothing else to the category. It could do with a bit of a bigger change.
Yeah, I certainly would think, to be honest with you, the process is much longer than what the old, I guess, sole rep used to be, right?
Yeah.
We used to do a heck of a lot of sole reps because it was a fairly structured process. It's not easy, it's structured. There is a plan almost. You look at it and how to expand. With the expansion worker route, it takes too long to get the license, almost, I would probably say. And I wonder if you were to limit the number of people, or rather, you're trying to limit the number of people who get on the sort of second stage. Can UK be attractive in that manner? Because would I want to set up with expanding in the UK, doubling my people to set up in the UK, and then go, where am I gonna hire? Right? I think it has to be a combination of businesses need to know that they can actually hire locally if that's the plan, right? There's a skill set that they can do, and they don't really need to rely on overseas other than the setup. Then, yeah, the doubling of the initial sort of A team, let's just say, to set up the subsidiary or branch on the expansion worker would truly explode, I guess. But without that sort of fundamental, there's that sort of talent backbone in the UK. I think it'll just be another sort of almost, I don't want to use the word gimmick, but it almost like a gimmick then.
I agree.
The next, Antonio, I think you mentioned this at the start regarding dependence as it related to, I believe, skilled worker visas. Can you share some more insights on what you were referring to? I believe dependence now, the white paper would propose that dependence would be limited or would be restricted for lower skilled roles. Is that correct, or am I off base there?
No. So I think it's part of the overall process to limit the workers, right? So the white paper already sort of stated, those who are on level 3 to 5, effectively, they're going to be reviewed anyway, and they'll be placed on the temporary shortage list as recommended by the MAC, and also, of course, salary threshold based on that. It'll be time bound anyway. I suspect, and I don't know whether that's the case, whether or not they will pin it on the same sort of principle around, the whether or not they can get settlement or how they would get settlement if they were to ever be able to. I think that's one of the things I wonder whether they will be looking at. But I guess that sort of follows through to the dependent side. And they've already mentioned, obviously, there's a limitation or limited means for them to sponsor dependents also in the UK. So that's sort of part of that. And I think that also double up the effort in terms of limitation of numbers would be the introduction of the English language as well. So it will be a progressive English language requirement from, A1, which is conversational, to sort of B1. And then settlement will be B2 as for everybody else. So that would cut a lot, because they obviously seen some success, of course, in terms of cutting or not allowing dependents to come in to join health and care workers, or not all health and care workers, of course, but the social sector side, seeing those numbers dwindling. They want to repeat, I guess, the dare I say, quote unquote, success of what they have seen, I guess, right? Again, I think, there will be a huge number of people that will be affected by this.
I hope it's like elsewhere in the system where you don't have to do a test at every stage, and you can just do one test at the start at the higher level that you need for your whole journey and use that, rather than have to resubmit a test at every point.
Well, if they meet the level, right? Like I would suspect they would do the same thing. If you meet the level already, then there's
makes sense, wouldn't it?
Yeah. Well, yeah.
We'll see. I thought it was interesting as well that it was only very briefly alluded to, but the fact that they plan to amalgamate or sort of streamline a bit the rules concerning spouses, dependents, and variations thereof. Because at the moment we've got all these different, we've got Appendix FM and we've got dependent rules and spouse. The Appendix FM and the spouse rules that we refer to are largely for those in a relationship with a British settled Irish person in the UK, and dependent is you are in a relationship with another visa holder, effectively. And I know that's caused a lot of confusion amongst private applicants, sponsors alike. And what rules do you qualify under? Do you switch accidentally from one to the other has been a common thing. And the rules are quite different, or very different, in fact. Like the salary requirements, the relationship requirements are similar, but there's far more flexibility around it nowadays. So I'd be interested to see if they make that easier for people to understand and maybe a bit more objective as well, because it's quite a lot of subjectivity involved, especially with the latest sort of not requiring cohabitation for unmarried partners. But we'll see. It was an interesting point. I thought they noted down.
Yes, simplicity. Unfortunately, I haven't seen simplicity for about the last 15 years, I'd probably say. It's never been fun reading the rules. I mean, we read the EUSS rules, and that's a fun one.
So Alistair and Antonio, during our previous discussions for this sessions, and just learning from both of you, there was one area of this white paper that seemed to me to be the biggest, like one of their biggest changes, and that is the 10-year track. And there's a lot to discuss, a lot to unpack regarding this particular area here. So I guess, Alistair, we'll start with you. Can you just set the scene for us with this, what the white paper discusses when it comes to the 10-year track?
Yeah. So the current situation is that after 5 years continuous residence in the UK, certain categories of visa holders would be eligible for what we call indefinite leave to remain. It's known by a variety of terms: indefinite leave to remain, permanent residence, settled status, settlement. But by and large, it means the same thing. You're free from immigration control. You can give up your sponsored job. You can you're no longer under the control of the immigration system. So historically, that's been 5 years for a long time now. There is a 10-year route where you could amalgamate different categories, but we're looking here at the one where you're focused under one category. the proposal is that you would they would move from 5 to 10 years, qualification period. So if you do come on a work visa to the UK, you would have to spend 10 years on that visa, still potentially switching between employers, but it would be 10 years cumulatively across all employers before you can get your settlement. And they use this phrase "earned settlement," which is as vague as the way I say it. We don't know how you earn it. And part of me, I think we sort of, as we were chatting before this call, I did say I do wonder if this is the points-based style Aussie scheme where it's not points based because you have to get every single one of the points. So it's not earned because you earn it by having to qualify for it in the first place. I don't know, but I do wonder if we're going down that route of a name to something where actually you question whether it lives up to the name that they've given it. But the big news is it's going from it could go from 5 to 10 years. We don't know if it will be retroactive. There's a lot of talk on social media about whether it will be retroactive to people already in the system. And it has an impact, obviously, for both individuals massively and employers, because you will be responsible for the compliance of that individual for 10 years. You will be responsible for tracking their visa expiry date, their address, whether you'll be reporting on them on the sponsor management system. And of course, the financial implication as well. So currently, a work visa for a large organisation for 5 years costs ballpark figure of £12,000. That's everything all in, the NHS fee skills charge. This would bump that to closer to £30,000, which it just blows my mind that you would. A few years ago, when we were talking about visas being about £1,000, that was it, and that's before you add in family members. So. Again, something that Antonio and I talked about was if you can bring your children under the age of 18 to the UK as a dependent. You do that on a work visa, and you've got a 17-year-old daughter or son. By the time you get to settlement, they would be 27. Like that again. That just I find that very hard to comprehend. And again, if you're a sponsor and you're covering these fees for them, you're covering for the main applicant and their family. And I've already seen some sponsors saying, actually, we'll cover a spouse and one child. That's it. If you have more children, the fees are on you. And I think it's sort of, again, going back to the point about knowing your population, it's knowing your potential outlay for situations like this.
Antonio, what are your takeaways from the move to the 5-year track to a 10-year track?
Fearful, I would just use that word. It's because of the unknown, I guess. But yeah, again, there is a consultation that's going to be had, but you're absolutely right, Alistair, in the sense that, yeah, changing to 5 to 10 would have a huge impact on anything financial through to obviously time and so on and so forth. I mean, what is earned? That's $1 million question, or at least 30,000, as you say, right? But it is certainly that, and I wonder whether or not paying taxes on time, because it's PAYE anyway, your everyday life, you buy a house, rent a house, whatever may be the case, is enough to contribute. Again, they're going to set criteria, or they're going to draft criteria as to how you earn it quicker. But the cost is immense. I mean, the example you've given, there's also about a 17-year-old child or even 15-year-old child, right, coming to the UK 10 years later. The person could potentially be independent, leading an independent life, working. They might be taken out of the route. They might need a work visa themselves. So what are we looking at, right, at the time? So that could potentially be that issue as well. So I think there are some complexity around changing from 5 to 10 years, not least that I think it will not attract as much of the talent pool, or the so-called much needed talent pool that employees actually need. So forget about all this planning for now. It's, offering you the job attractive enough, because there is sort of almost, other than working, there's sort of no end game effectively, or that we used to. Right, I think UK has always been one of the more popular places. Forget about all the other elements. Is that UK immigration so far, anyway, for the last so many years, despite changes we keep talking about, they're quite stable and structured. right? We almost know what we're going to get, right? There's not a lot of lottery going on, so to speak, in that type of stuff. It's do you meet the rules or do you don't meet the rules? And this gives a lot less certainty because how would I? It's easier to plan 5 years. You tell me to plan my life 10 years. It's very difficult to get that crystal ball and get it right. So you can have as much data as you want, but it will be a guess. By year four, things might have turned around altogether. So I think it adds a whole load of complexity to it, but certainly the attractiveness of it. And Alice is absolutely right. A lot of employers that we speak to, I mean, some employers don't already sponsor the workers' dependents. They would say, sorry, that's your cost. But imagine the cost outlay for an individual who's working, earning a normal salary. How are they going to pay for all of that for their family as well for the next 10 years? It's an investment in itself, right? Plus, you probably have to pay more in anyway because of the plans and the change of immigration rules. I think it's a huge problem for that reason, and certainly for the employer as well. I've alluded to that. I mean, 32% increase of immigration skills surcharge or immigration skills charge. It's not something to laugh at, right? In that sense, yeah, it's supposed to be bringing it in line with inflation, but over the last 5 years, I think they've already made about 1.5 billion out of immigration skills charge. I think from 2019, and I think estimated 2024. So I think last year was about 600 and something or 500 something million. It's a huge number, and 32% will make more money, so to speak. But if that deters people from coming or attracting talent, then those numbers won't stack up. It doesn't matter how, even if it's 100%, it won't stack up.
I think it's we talked to a client a few months ago about building a mobility program, and many of the companies we work with, we support them and we do a lot for them in terms of compliance, but you can't get away from the fact that HR or a mobility team have a role internally. You can only outsource so much. They need to know when somebody goes AWOL. They need to know when some start date changes, etc. And it needs to feed through to us into the government systems. And I pitch to them that if you've got a large population, you can expect to have 2-3 people doing that full time, just monitoring your migrant workforce for a very large sponsor. And if you're having to wait for people to get out of your system for 10 years, they will be your responsibility for 10 years, then your need for 2 or 3 people managing that goes up to 6, because the visa process is the easy bit. It's the quick, I should say it's highly complex, but it's not. It's the tip of the iceberg, and the work that comes after is the compliance and the maintaining your license, etc. So if that period, if you having to do that is going from 5 to 10, I think it does have a huge impact on individuals. But sponsors should be acutely aware that if this comes to fruition, they should think, well, what is my input going to be to remain compliant? How much more effort will we have to expend in doing so?
Well, more to come. We'll stay tuned and see what's coming out of the news. So I guess Antonio and Alistair, with that said, what are just really briefly? We're at about the 10-minute warning until we're wrapping things up. We've talked about a lot about what is changing. Are there any aspects in this white paper that, when you look at the UK immigration, that are not changing?
Yeah, I mean, I think we've mentioned some of those certainly. So for those who are already, I mean, even with the, let's start with the social care sector. I mean, they're cutting the route altogether, of course, by 2028. But those who are already on the route can continue to extend until that time. So I guess it's changed, but for now, it's status quo. So also on the skill level side of things, things might have sort of or likely to increase to level 6. They've already mentioned that. But what won't change are for those who are already in the UK. So that skill level will remain. Threshold, unfortunately, I think, like the other time, there will be some sort of stealth movement based on whatever the sort of percentile that they're looking at. But certainly, at least for skill level, that's not going to change. For family members, of course, of British citizens, that's already been promised and verbally, and also obviously on the white paper as well, that's not going to change in terms of that route for earned settlement. It won't be sort of part of that. So those are sort of some of the positive, I guess, or those are the rock solid that we can sort of see from the white paper at this stage.
And I think as well, there are changes that have been flagged, but it's being aware that whether it will impact you. Like, so to give you an example, like the intention to increase the English language level for skilled worker and other work groups from B1 to B2. People might ring alarm bells at seeing that, but then when you dig down into it, well, actually, most of the people that you're hiring in the UK are likely to have an English taught degree, and you can use that instead. Because it's very rare that you would get an English speaker unless they're from an English-speaking country that hasn't studied in English and coming to work for a large organisation. So I think it's not only being aware of the changes that aren't happening, but it's being aware of changes that are happening but might not actually impact you as much as you may think from scanning through the paper.
Got it. What are your guys' expectations, if you will, of when we'll see this move from white paper to actual like things coming out, or what should our audience where should they follow to see updates regarding this white paper, and like when things are actually passed through the legislative process, if you will?
I think a lot of it will be social media. Home Office is very good at publishing things. That's they probably know faster than everybody else. There are a lot of debates already talking about that. Hansard publish things a lot as it sort of develops, I guess. So we get a lot of the news fed through to us as well, and we work with those to make sure everybody's in the know, so to speak. But in terms of, there will be some quick movements in terms of implementation, I would think. I mean, on the fee side of things, immigration skills charge, I would assume that would move fairly quickly, because that's sort of the easy win for on this white paper is increasing statement of changes again. The other things might be a bit slower. I'll probably say, I mean, the white papers say, by the end of the year, they want to do a lot of things. I wonder, because there are a lot of factors now to factor in from the latest ONS scores, I guess, of statistics that came out about, reduction in net migration. So that's to consider. Almost, I would guess politically how fast you would move. There is a recent MAC report came out, I think today. It was delayed because of the white paper on IT and engineering. They've made no recommendations, as far as I understand, briefly sort of glance over it, but certainly doesn't suggest there has been sort of any sort of type of abuse, as far as I can understand, of the system. So they might have to think twice again about how fast they would want to implement it. But certain things, as I say, will take longer, definitely. The 5 to 10 year, I think, is great impact. They need to still draft up, make it make sense in terms of what earned citizenship and earned settlement is going to look like, and how those impact assessment needs to be done, really. So I think there are certain wins. The fees, the skill level, even could probably be implemented fairly quickly. It's been done before. The more prominent ones, settlements, would take later. The levy, certainly, on higher education providers will take longer. So I think they will come in parts.
Yeah, I agree. I think anything that you think that looks quite precise, is it 32% the increase? It's around that. Anything you think that looks quite precise, that's probably precise because they can implement it quickly. Anything you look at and think that looks incredibly vague, I think it's probably incredibly vague because it's still incredibly vague internally within government, and that's going to take a long time until it gets to the 32% level of precision that they need to implement it. And I agree. I don't think this. I'd be astonished if all this comes in one great big release, that it all comes into law at the same time. I think it will be either drip fed or it will be released, but with different dates of assent. I can't see how they can implement it all in one go.
Great. Well, Antonio and Alistair, we are just nearing the end of our allotted time. So I want to thank you both for joining today's LinkedIn Live session. It was really informative. I learned a lot. I hope our audience found it informative. For our audience and just in general, we're going to take this recording and upload it to our YouTube channel. So if you missed it or want to watch it later, it'll be easily accessible there. And if you want to learn more from Antonio or Alistair, maybe talk with them if you're looking for a better way to manage your global immigration program, head over to envoyglobal.com to learn more about our services and the Envoy Global platform and how we make immigration easier for companies and the global talent they depend on. And you'll also be able to ask your questions to Antonio and Alistair if you are looking to expand in the UK or have any questions about any of the topics we discussed today. Antonio and Alistair, the door is always open for future LinkedIn Live sessions. So as updates come out in the future, more than welcome to hop on another session and discuss as needed. So thank you so much.
Thank you.
That's perfect.
Thanks all. Bye.